Welcome to Canadian Justice. I'm Christine Van Gyn. Today we're talking about Twitter and free speech. When a politician uses Twitter as a platform to make public announcements and discuss political views, does that make the account a public platform? And if that politician decides to block a critic on Twitter, is that a violation of the critic's freedom of speech? For those of you uninitiated in the ways of Twitter, when you block a user, they can no longer see or comment on your posts. The blocked user can log out of their account and read your tweets, but they won't be able to comment. Many politicians have made generous use of the block button, and it's hard to blame them. Twitter is filled with anonymous troll accounts, bots, and plenty of just mean and nasty people. But it's also filled with journalists, with politicians, people who are just concerned about major public policy issues, and advocacy groups. And there are politicians who have blocked some of these good faith users. For example, Bloc Québécois leader Blanchette has blocked dozens of Twitter users, including other MPs and advocacy groups who have criticized him. When asked why he blocked these users, Mr. Blanchette said, "When I block people, it's because their posts don't interest me. That does not prevent them from posting. I just won't see them, nor them mine." And he added that things are calmer that way. While Twitter is a private entity and not subject to the Canadian Charter of Rights and Freedoms, some experts have argued that it becomes a public platform when it's used by politicians. Should politicians be free to block users, or is this an unjustified infringement on freedom of expression and damaging to democracy? Today, we'll be digging into these questions and more, and I'll be joined by two individuals who use Twitter for public advocacy: Duff Conacher of Democracy Watch and Kaveh Shahrooz, a lawyer and Canadian human rights activist. We'll be then joined by a panel of legal experts. Duff, Kaveh, thank you so much for joining me. Duff, let's start with you. Why shouldn't a politician just be allowed to block someone on Twitter? I mean, it's their own platform. Why can't they use it to do whatever they want?
Well, I think Twitter is equivalent to the politician's email account, politician's phone number, fax number, and those you have to keep open and available to constituents and voters to be expressing themselves by calling you, emailing you, and letting you know their views. So I see Twitter as the equivalent of that, and to block someone means they cannot respond to things you are saying, and that I think a court would rule that that would be an unjustifiable restriction on someone's freedom of expression, given that the person is an elected official who is paid for by the public.
So Kaveh, what's your view on this? Do you think politicians should be able to block whoever they want on Twitter?
Listen, Christine, I'm really of two minds about this. I would obviously prefer that politicians not block people, but I can sort of understand the justification. Duff compared it to, a politician's email account or phone number. I actually don't think that's necessarily the right analogy. I think a Twitter account is a little bit like a politician's press conference. That's where politicians go to put out their statements. And I don't think any of us would think it was particularly strange if a politician, kept certain people out of their press conference. And I don't think rights are necessarily affected. Like, if I want to say something about a politician, I can still do that. I can still see their tweets, and I can get the news from other news sources. I don't necessarily see the right of replying on Twitter as being necessarily that critical to my right to free expression.
So, Duff, what do you think this does for democracy if a politician blocks one of their critics on Twitter? Is it a really damaging thing to do, or is it sort of in the gray area, as Mr. Shahrooz suggests?
Well, first of all, it depends what the critic is saying in their replies. I think if they're saying hate speech and discriminatory, kind of slanderous kind of posts, then I think that a politician, if they could show that, would have good reason to block somebody. They don't have to file a defamation lawsuit every single time that someone would reply with defamation in order to stop that kind of communication. I think they should have the right to block that kind of criticism, just because it's dishonest, essentially. But honest criticism, where someone's expressing an opinion, I see the analogy of being a press conference, but I think it's much more than that. It is a two-way situation.
Duff.
You know that you are setting up with your posts that you're sending them out for people to reply.
Duff,
And to shut that off, I think it shuts off the conduit of free expression too much.
Welcome back to Canadian Justice. We're discussing what it means for freedom of expression when politicians block their critics on Twitter. Kaveh, if an advocacy group is blocked on Twitter, it's not as if they're silenced completely. It's just one forum among many. So does getting blocked on Twitter really matter?
Well, I think it matters. Being able to reply to somebody's tweets and getting eyeballs on it is certainly important. But I don't think it's the biggest deal in the world. And in fact, for those of your viewers who are not Twitter users, there is a feature where you can actually turn off the ability of other users to reply. And so I think that roughly achieves the same thing. And I wouldn't say that that's actually a violation of free expression either. So again, I would prefer that politicians allow people to comment. I would certainly with respect to journalists and advocacy groups. But I think given all the threats that we're facing to free speech from both left and right, I don't see this as a major issue for us to be concerned about.
Duff, I want to get back into one of the things that we were talking about before the break, this analogy to the press conference. You know, a politician can write an op-ed in the Globe and Mail, and it's not as if you have a right to reply in the Globe and Mail. Is there a difference between the right to speak and the right to be heard? Because we also know that politicians can simply mute their critics on Twitter and they won't see the tweets anyway.
That's true. But if they're setting up that platform, I think going as far as blocking someone is shutting down freedom of expression too much. I'm not sure whether we'll ever see a court rule on this because the politicians who have been challenged, for example, Jim Watson, the mayor of Ottawa, ended up unblocking people after they filed a court application. But if you're going to use the platform and you're a public official that the public pays for, then I think you have to keep the platform open. And you may want to mute so you don't hear the replies. That's the equivalent of not opening people's emails. But to not allow the emails to be sent that would be equivalent of trying to hide your email address as an MP or public official. And I think that goes too far. The public has a right to respond and send its reply, whether you read it or not.
And Kaveh, how do you respond to that sort of email analogy that it's the equivalent to just not making your email address public? I mean, politicians don't make their email addresses public. We all know that there's a general inbox you can email your MP, but I certainly don't have the personal email for my MP.
Yeah, I think that's right. I mean, I think the politician's email is what it is. And if you really want to get in touch with that politician, you can go and send them an email. You can send them a letter. Those avenues are still open to you. It really depends on how you use Twitter. But again, I go back to my initial analogy of Twitter being like a press conference. If you use it as just a way of putting messages out in the world, I don't necessarily see it as problematic where, people won't have the right to respond to it on that particular platform.
Now,
they aren't personal accounts, though. I mean, when they set up an account as a public official, it's the account of a public official. They can't say, oh, this is my personal account. I'm taking my official hat off and just using this account personally. They just can't do that. They're wearing the official hat, and when they set it up, and then it has to be open to all voters to respond to.
Does it make a difference if they're using it sort of for both things? I mean, politicians post pictures of their families at Christmas time, as well as using it to make public announcements. Can it operate in sort of both worlds simultaneously?
Certainly for cabinet ministers, there have been guidelines set out saying if you have an account, it's your official account. You can't take your hat off. You're a cabinet minister, and that account is your official account. So those guidelines have been set up because of confusion and some ministers trying to play that game of saying, I'm just commenting personally, and rightly so, I think, because the public is paying for them. They're doing the job and they're making posts about their job. So it's their job's account and has to remain open to all voters to respond to.
And what about politicians who are frankly harassed? I know there's some politicians in particular, and let's be honest, it's usually female politicians who are subject to horrible abuse on Twitter. Do you think that there's a problem blocking tweets that are abusive, but also might sometimes have good criticism? That's for you, Duff.
As I mentioned, if it's defamatory, if it's that kind of abuse, harassment, hate speech, I think the politician, any public official has the right to block those kinds of things. They don't have to tolerate defamation and libel and slander.
And Kaveh, do you have a response to that just in 10 seconds or less?
In 10 seconds or less, I'll say that Twitter is actually two different features in one. One is getting your message out, and the other is, replying or hearing replies. The reply part, I think, is the part that I'm not so concerned with, because I don't think you necessarily have a right to reply on a particular platform.
Welcome back to Canadian Justice, where we're discussing whether a politician blocking a critic on Twitter is a violation of that critic's freedom of expression. Joined by me now are two legal experts on freedom of expression, Dr. Richard Moon, a professor at Windsor Law, and Dr. Maxime Saint-Hilaire, a constitutional law professor at University of Sherbrooke. Thank you both so much for joining me today. Professor Moon, why can't a politician just block whoever they want on Twitter? I mean, it's their account.
I'd like to sort of preface, an answer to that with a more kind of complicated. But why can't they? Well, it may be they can. We don't have that question really resolved at this point, but there is a real issue as to whether they should be able to. And it really comes down to whether we want to see a Twitter account as a kind of public forum that individuals should be able to access in some way, either as simply audience members who can see and read what's been posted, and perhaps also to comment. So that's really the question. Let me just preface this by saying, the fact is that our thinking about free speech, our free speech doctrine, grew up in a very different context, and we're having to rethink significantly how we understand it and how we apply it to new media of different kinds. And that's the real challenge.
Okay, so Professor Saint-Hilaire, can you respond to that? What's your take? Is blocking a user on Twitter a violation of that user's freedom of expression?
Well, I agree with my colleague that the current state of Canadian law on this is unclear. It was decided in the U.S. as you may know. The U.S. Court of Appeals for Second Circuit just reaffirmed the decision that ruled that blocking someone on his account by President Trump was an infringement of the First Amendment. I think it's interesting to wonder whether this can be transplanted in Canadian law. I think, first of all, there's an application of the Canadian Charter issue, because the Canadian Charter applies to the government. It certainly applies to ministers, but the question whether it applies to MPs, MLAs is a bit more complicated. The Supreme Court in New Brunswick Broadcasting said the Charter applies to Parliament and legislatures, and this means that it also applies to parliamentary houses, chambers. But it's unclear whether or not it applies to member of parliament and member of legislative assemblies as well. I mean, it's arguably the case, but then there's a parliamentary privilege issue. So if a member of parliament or member of a legislative assembly is using his Twitter account in this capacity, I mean, the question needs to be posed, to be asked whether or not there might be instances where the Charter does apply, whereas the parliamentary privilege doesn't, and this is unclear.
I certainly read about that Trump decision. It was fascinating, although I guess the point is moot now that his account has been deleted. Professor Moon, I want to follow up on something Professor St. Hilaire had just said. You know, the Charter covers government action, and Twitter is a private entity. So why does the Charter even apply here?
Well, of course, you're right. The Charter applies to government action or state action, and that given that Twitter itself and other social media platforms like Facebook are privately owned, it appears that then the Charter is not directly applicable to them. The question is whether we can see the individual account of a political actor as a state act, as a government action of some kind. And particularly if they use that, as, say, Donald Trump did, as a way of stating their positions or announcing policy in some way. But even when they present themselves as a political figure to the public world, even their image, I mean, as you described in the previous section, the idea of a politician offering a photo with family. Well, that's still, we know in this contemporary environment, in a sense, a political act. It's a construction of one's public image in some way. So it really is about distinguishing the account from the platform itself and whether or not we can view the particular feed or the particular account as itself an act of a particular state actor.
It's a fascinating conversation. We're going to pick it up right after these messages from our sponsors. Welcome back to Canadian Justice. I'm your host, Christine Van Geyn, and we want to jump back into our discussion about free speech and Twitter. Professor St. Hilaire, if a politician blocks you on Twitter, you can still criticize them. They just might not see your criticism. Is there a difference between freedom of expression and the right to be heard?
Well, the argument was made in the Trump case, and I think it's relevant to look at how it was dealt with. What was ruled is that when a politician blocks someone on Twitter, it's not only a matter of the communication between the politician and the blocked user. What was ruled is that the official public use by an elected official of a Twitter account creates a public forum. But what the court meant by that is that it creates a public in interactive space. So it's also a matter of communication between different users. So it's not like a press conference. That's not the way U.S. courts conceived of the issue. So this is why it was not government speech, because if it was government speech, First Amendment couldn't apply. So the very act of blocking was not only a matter of cutting the communication between the elected official and these specific users. It was a matter of excluding someone from an account of a use of a Twitter account that created a public forum that was interactive from the start. So I think there lies a difference. But if we try to transplant this or transpose into Canadian law, I mean, it's tricky because I'm not even sure what kind of infringement it would be, what category it would fall under. Would it be a claim of exclusion of an existing tribune? Or would it be more like a BC Transit case? Would it be more a case like someone has been blocked because of the specific content of a given speech? Right. This is a different category. Right. So it's not. It raises a series of quite tricky, complex legal issues.
So, Professor Moon, the Charter is subject to reasonable limits. You can limit a Charter right. What do you think the reasonable limit would be in the case of blocking someone on Twitter? Could this be justified if it is a rights infringement?
Yeah. Sure. I mean, obviously, speech that is unlawful, but even speech that is harassing in character that might not be unlawful. But that actually points to what is another one of the real challenges with trying to, transpose our thinking about public forums into this new and different context, and that is, if the Twitter user, if the account holder decides that speech is sufficiently nasty or harassing in character, and they're going to block it.
Yeah.
Do they have to justify it? Can that decision be challenged in some way?
Yeah.
I mean, we have processes for that under the charter, but it's not exactly clear how the limitations provision, or at least the process that relates to limiting administrative decisions, would apply in this context. So again, this just takes us back to this problem of this is all very different, and the concepts and the categories are different, and we're going to have to be pretty creative in thinking about how we translate our current doctrine into this new context.
Thank you both so much for your wonderful insight today. It's been a fascinating conversation. We've heard today about politicians who don't like being criticized and who have blocked their critics on Twitter. While this type of behavior is petty and isn't good for democracy, does it violate the right to freedom of expression? Freedom of expression is a fundamental right, and it's a right that we use to define the contours of all our other rights. The right to criticize government, and politicians in particular, is fundamental to the functioning of democracy. But the right to speak is very different from the right to be heard. Government critics have no shortage of platforms, and being blocked on Twitter doesn't mean that critics are forced into silence. There's never a guarantee politicians will listen to their critics anyway, even if they aren't blocked. We've also heard legal arguments about why the right to freedom of expression means politicians shouldn't block their opponents. But should this issue really be considered a violation of freedom of speech? Should politicians be able to block whoever they want on their own accounts? You be the judge. I'm Christine Van Geyn, and remember, a freer Canada starts with you.